Closing arguments are underway in Hunter Biden's federal gun trial in Delaware. His lawyers rested their case this morning, and the president's son didn't testify after all. Hunter Biden arrived at court this morning with his wife by his side. First Lady Jill Biden was also there to support her stepson. I want to bring in CBS News legal contributor and Loyola Law School professor Jessica Levinson for more on the trial. So, Jessica, good to see you. The defense decided not to call Hunter to testify, totally within their right, would open him up to all kinds of questions in cross, right? I mean, what's their thinking here, you think?
I think there's a reason that most defendants do not take the stand, and that's because it is extraordinarily risky. We had this conversation with respect to a former president recently. I know there's a lot of interest in, well, if he wants to defend himself against these charges, why wouldn't he just take the stand? And I think your question points to the answer, which is he would subject himself to, I think, very painful cross-examination. And you have to be really sure that, I think, one, you're going to lose without putting your client on the stand. And two, your client is going to make this better, not worse. And completely predictable, Hunter Biden and his attorney, Abby Lowell, decided that he would not testify on his behalf. So
also related to a former president, not a president's son, but former president, the all-important jury instruction sort of tells the jury, this is what you can consider, this is what you can't. For example, you can't, correct me if I'm wrong, use the fact that Hunter Biden did not testify against him. He's within his right to do that. How important are the jury instructions in a case like this?
So that's exactly right. I mean, this is the roadmap for the jury, saying to them, you can't hold it against somebody that they're exercising the right not to testify. So how important are the instructions? I will say this case is not as complicated as some of the other cases that we've talked about before. And so this case is a little bit more straightforward in the sense of there are two allegations that Hunter Biden lied on a form that he said he was not a drug addict when in fact he was. And then one count here dealing with possession of a firearm. Legally, these aren't particularly tricky. So I would say, well, jury instructions are important. They're not as important as they are in a really complex case where you have to say to the jury, step one, step two, stop for a minute. Here's what it takes for step two. Now step three. It's not that type of case.
Hunter Biden's defense lawyers have used the defense that he didn't consider himself an addict at the time. So he didn't consider himself lying on that form. But the prosecution, they have introduced a lot of details into Hunter Biden's personal life, text messages, details from his memoir, testimony from a former wife and former girlfriend. How ironclad do you see each side? And also, is it different that this is taking place in a federal courthouse?
Well, these are federal charges, so it has to happen in a federal courthouse. And obviously that is different in the sense that it's much more formal. There are different rules of evidence that come into play. But in terms of the specific charges here, obviously this isn't a state crime. This was a federal form that we're talking about Hunter Biden allegedly lying on. Now, with respect to, I think you were exactly right to zero in on that word addict, because that's what the defense has hung a lot of the case on. Really, there's a two-pronged defense. One is the word addict is just vague, and Hunter Biden might not have understood what it meant, and therefore he wasn't lying. He didn't form that intent when he said, no, I'm not an addict, in order to purchase the gun. And the other is that he didn't understand himself to be an addict, kind of related to the first, within the definition of whatever addict is at the time that he bought that gun. Now, is that an argument that the jury's going to buy? I would say it's the best argument that they could make under the circumstances and given the judge's pretrial ruling involving other things that they could not argue. I know they wanted to bring up a Second Amendment argument saying that this particular federal law actually violates the right to bear arms. They weren't permitted to do that. We could potentially see that on appeal if there is a conviction.
We're talking about sort of the end, nearing the end. We're at least in a new phase here of the trial. But I want to take that idea and go back to the beginning. Voir dire, I don't know how to pronounce it, but the questions that the jurors are asked when they're selected, and we know that their thoughts and feelings about drug addiction, whether they know anybody who's personally battled addiction, played into that. So can you take us into how that might come into play now?
So I think the prosecution is hoping that for the people who either know somebody or themselves were former drug users, that they will essentially say, these people knew that they were drug users. And yes, this is a very difficult struggle, but people know whether or not they are addicts at the time that they make a purchase. I think for the defense, they're hoping obviously that there would be a lot of sympathy with those, again, who are related to or know a former drug addict, and that they would say, it's kind of actually a squishy term in the sense that people might be using drugs, but not consider themselves to be a drug addict, depending on the day or the week. And so that's how I believe that's playing. I will say it's an interesting comment in the sense that both sides, I think, acknowledge that it'd be very difficult to have a jury where you don't have anybody who's related to or knows somebody who's struggled with addiction.
Okay.
And just one more thing,
Yeah.
again, of course, that isn't the point. The point isn't to have a jury who's had no life experience. The point is to have a jury who can go in there, look at the jury instructions, listen to all of the evidence, and then make a determination.
Okay, Jessica Levinson, thank you.